Many of the others you've done purely for property tax abatement purposes. No.
Public hearing. Discuss the ordinance to authorize issuance of bonds or AMP Limited Liability Corporation for property located at 1300 Mayor Lane.
This is a new facility, cold storage warehouse. Again, you passed an inducement resolution on this one earlier this year, and now they're proceeding. They're already moving toward constructing this facility, but same type structure, and this one is not to exceed $50 million.
Any questions for Mr. Welborn?
Just a clarification on both of these issues. To be clear, this is not money the city was borrowing,
Correct,
or repaying, or on the hook for.
It is not. It is purely a kind of a quirk of Arkansas law and a number of other states that in order to do the property tax abatement on this the facilities, this is the way you have to go about doing it, but no obligation on the part of the city.
Thank you, Mr. Welborn. Thank you, Mr. Grimes. Anyone else like to speak for?
I spared you on the first one because you heard from me in the last meeting.
Name and address, please.
Oh, sorry, Mayor. Corey Parks, 532 Faulkner Street. Appreciate your continued support of a pro-business climate. As Mr. Grimes pointed out, this does not obligate the city in any way, and so would appreciate you all continuing to support, again, the pro-business climate in Conway.
Thank you, Corey. Anyone else like to speak for? Anyone would like to speak against? We will declare this public hearing closed. Next, we have the Economic Development Committee and Mr. Hawkins. Nope, I'm sorry, this is still me. First up, we have consideration to approve the waiving of all three readings for the ordinances in the November 12th City Council meeting.
Make a motion to approve. Second.
Have a motion and a second to approve the waiving of three readings for tonight's council meeting. Any further discussion? Mr. Garrett.
All in favor, say aye.
Aye.
All opposed.
Passes 7-0. Next, we have an ordinance to approve the issuance of bonds for Clayton Homes Building Group for property located at 901 McNutt Road. This is what Mr. Welborn was speaking to shortly.
Nothing really additional to say about it, but this is the ordinance that approves those bonds and all of the documents that kind of go with it.
Thank you, Gordon. Council, back to you.
I'll make a motion for the adoption of the ordinance, and I have that as ordinance number 02474. Is that correct? Second.
Have a motion and a second to approve the ordinance for issuance of bonds for Clayton Homes Building Group. Any further discussion? Mr. Garrett.
Mr. Jones?
Yes.
Mr. Hawkins?
Yes.
Ms. Mel?
Aye.
Mr. Cummins?
Yes.
Mr. Hawks?
Yes.
Ms. Isby?
Yes.
Mr. Grimes?
Aye.
That passes 7-0. Next, we have an ordinance approving the issuance of bonds for the AMP Limited Liability Corporation. Mr. Welborn.
Again, nothing different about this ordinance. They're remarkably similar if you put them side by side. It approves the issuance of that issue of bonds, and then the trust indenture, lease agreement, bond purchase agreement, and pilot agreement that go with it.
Thank you, Mr. Welborn. Council, back to you.
Move for adoption of this ordinance.
Second.
Have a motion and a second to adopt this ordinance approving the issuance of bonds, bonds AMP Limited Liability Corporation. Any further discussion? Mr. Garrett.
The ordinance 02475. Mr. Grimes? Aye. Mr. Jones?
Yes.
Ms. Mel?
Aye.
Mr. Cummins?
Yes.
Mr. Hawks?
Yes.
Ms. Isby?
Yes.
Mr. Hawkins?
Yes.
That passes 7-0. Thank you, Gordon. Next, we have a resolution to approve the reimbursement cost expenses incurred for the connection with the construction of Conway Corporation Operations Center for Conway Corp. We have Mr. Brett Carroll here tonight.
Thank you, Mayor, Council. Brett Carroll, 330 Conway Boulevard is where my wife lets me live. So a couple things on the agenda here. The first of is you guys may have seen our project on East German Lane, South German Lane. Pardon me. It's coming along really nice, so we hope to be finished with that before the end of the year. And hopefully we'll, if you guys would like, we'll give you guys a tour of that. It's really an outstanding facility that's going to give us years to grow for the long term. Unfortunately, if you guys have been involved in projects, you know, things have increased over the past few years, and that's no different here. For factors beyond our control, and we did some short-term borrowing to help finish this project out, and it's a $39 million project. And you know, we may have some opportunity in the bond market to kind of improve the economics on this, and so this just is a resolution that allows us to reimburse ourselves if we decide to issue bonds to help finish this project out. And consistent with earlier discussion, it does not obligate the city, does not cost the city any money. So that's, I just want to make that clear as well.
Thank you, Mr. Carroll.
Any questions? I'd be happy to answer those. Have you guys seen that, by the way?
I have.
Yeah, it's coming along.
Where is it located?
Sir?
If you get a chance, I did a walkthrough with Brett the other day, and the Richie Arnold, it is really a nice facility. Back to you, council.
Make a motion for the adoption of the resolution R-2459.
Second?
Have a motion and a second to approve this resolution. Any further discussion? Mr. Garrett.
All in favor, say aye.
Aye.
All opposed.
Passes 7-0. Next, we have an ordinance to approve the amendment of ordinance 02402, revising the effective dates for Conway Corporation. Mr. Carroll.
Yeah, this really doesn't change the intent at all of what we talked to you guys about in February. There are a couple of sections there, though. One, Section 10, which talks about out-of-city rates, should have been Section 9, which is fire hydrant meters. And so the out-of-city rates are just 150% of whatever the in-city rates are. So there's really no impact there. So we need to change Section 10 to Section 9. And then there was a sentence that we left in inadvertently that said that the provision, and this is the indexing that you guys have allowed us to do, the provision is effective April of 2025, and it needs to be February of 2025, which is what it said in the earlier part of that phrase or that paragraph in the ordinance. And so that's really all that we're asking to fix here. Be happy to answer any questions.
questions,
that
Mr.
you
Carroll?
guys- I've got the ordinance right here, Mr. Jones. If I can be happy to bring it to you.
That was the previous ordinance that you're referring to.
That's correct.
Okay, because what we've got is the ordinance that just has through section 4.
Yeah. But I do have that if you'd like to look at that.
Not part of the packet.
You mind just passing it?
Not at all. So here's Section 9, which is the fire hydrant, Section 10. I talked to the mayor while they're looking at that. Talked to the mayor recently. There's a lot going on in the city and at Conway Corp, and so it might be, you know, we're going to be doing another strategic plan with our board in February of next year. So it might be good if there's an appropriate committee meeting just for us to come by, or for me to come by and share kind of what's on our planning horizon for the next 5 to 10 years. There's a lot going on. I think you guys would appreciate just, you know, knowing what we're going to be working on.
No, I think that's a good idea. And it gives a chance for the public to hear as well.
Yeah, sure.
Yeah, good.
Might be a good idea just to know where streets are going to be impacted. From your standpoint or from our standpoint.
Sure.
It could be city.
Yeah.
Rather than Conway Corp. So I think.
Yeah, and we do our engineering departments. You know, Kurt and Jacob, they work in the engineering department really very well to try to understand. It's still sometimes we inconvenience customers, and I know that's a problem, but we do work closely together. They're really good about letting us know where they're going to be working, and we try to plan accordingly about what wastewater and water infrastructure we need to be working on. And sometimes there's flexibility. They'll allow us to, you know, push the street project back if we need more time. And anyway, so it's a great working relationship. But I do think that discussion would be helpful.
I think it's very important. I appreciate you bringing that up.
Yeah.
Thank you. Jones, are you good yet?
Yeah, I was passing around.
Oh, okay.
I know,
I'm sorry, I just
did
didn't, I wasn't paying
back.
attention.
I got it.
I was looking at something else.
No, you trying to rush over me.
No. Do we have a motion on this yet?
We do not.
I'll make a motion for adoption of the ordinance.
Have a motion, and a second, to approve this ordinance, revising the effective dates for Conway Corporation. Any further discussion? Mr. Garrett?
The ordinance 02476, Mr. Hawkins,
Yes.
Mr. Grimes,
Aye.
Mr. Jones,
Yes.
Ms. Mel,
Aye.
Ms. Isby,
Yes.
Mr. Hawks,
Yes.
Mr. Grimes. I'm sorry, Mr. Cummings.
Yes.
That passes 7-0. Thank you, Mr. Carroll.
Thank you.
Next up, we have I'm struggling. Community Development. Mr. Hawkins, I will turn that over to you.
Thank you, Mr. Mayor. First item here is an ordinance appropriating funding for the purchase of property located at 1015 Oak Street. This has a building on it, 6,600 square foot building, a property praised at $457,000. And we have an ordinance to be read for this item. It's ordinance 02477.
I'm not sure, don't hold me to this. I think this may be the old Ham Beacon Furniture Store. Does that sound right?
The lower one.
Yeah. From years ago. It's immediately east of the old Courtmeyer Furniture Building there, right on the edge of the alley there. Would you explain what our goals are for this?
Sure. So this ties into the project that we currently, actually, we're finishing up the first stage of construction on those alley improvements back there, which is enclosing the storm drainage system. And this, obviously connects to that. As the mayor pointed out, this property is located immediately west of the alley, that mid-block north-south alley through there. Anyway, the second phase of this alley improvement project includes the hardscape improvements, the amenities. Basically, it's going to be a, kind of a park-like and pedestrian throughway there connecting Court and Chestnut, and then also Oak and Main. One of the, obviously one of the challenges downtown is parking. This space would enable us to, possibly add some more parking in that area. And then the other issue that has kind of come up with all this improvement of the alleyway is trash dumpster management. And this would also give us a space to kind of consolidate some of those dumpsters back in that area and kind of, so they're not in our park-like setting that we're creating back there.
And one thing Joe was checking in on for us is a compactor, large
Yeah.
compactor, so that all those businesses would be there and then they could just back up to it and get it. Also, council, the area, the first area we talked about that the city has purchased, there will be additional parking in that. The businesses that are there, the sandwich shop and several businesses there, they're going to park. We're going to have designated parking for them during the day. And then when their business closes down, then that becomes public parking. And they like that idea. So it'll give them a place to park where they're not taking parking up front from their customers. They'll be able to park by their stores. But then when the nightlife kicks off, that will be public parking.
There'll be no construction on that street. Is that correct?
Which street is that?
The one that's going up right now, right there. No, right there.
Are you talking about Chestnut?
Yeah.
Okay, so Chestnut is a separate, that'll be a separate project. Now, when the utility relocation work is completed on that, then the city will come back in and, finish that project out with the sidewalks and landscaping, trees and planters and so forth, and then repave it.
That's
It'll look like Court Street when it's done, that section of Court between Main and Oak.
well, I'd like to get that one straightened up where people can get through there for a while.
We would love to get it.
Know what I'm saying?
Right, but this work that we're talking about inside there, that's not going to affect any of the streets. That's all going to be back in the alleyways, back in that area.
Thank you.
Any further questions for Kurt?
Do we have a motion?
Do not, Mr. Hawkins.
This is ordinance 077.
Second?
Have a motion and a second to adopt this ordinance for purchase of property at 1015 Oak Street. It also has an emergency clause. Any further discussion?
I think it was mentioned, but it's worth mentioning again that one of the main reasons this work is being done is to further help drainage downtown.
Absolutely, and it's made a difference.
Yes, and we've already seen some improvements in what we've done previously. This is no step toward improving drainage downtown.
Thank you, Mr. Grimes.
I recently visited Fort Smith, and they got a major problem.
Who's that?
Fort Smith.
Fort Smith.
Mm.
I was kind of bragging a little bit. About
Any further discussion? Mr. Garrett?
Ms. Mel,
Aye.
Mr. Jones,
Yes.
Mr. Hawks, Mr. Hawkins,
Yes.
Mr. Grimes,
Aye.
Mr. Cummins,
Yes.
Ms. Isby,
Yes.
and the mercy clause, Ms. Mel,
Aye.
Mr. Jones,
Yes.
Mr. Hawks, Mr. Hawkins,
Yes.
Mr. Grimes,
Aye.
Mr. Cummins,
Yes.
Ms. Isby.
Yes.
Those both passed 7-0. Now I want to give you some good news too. So this is all good news, but if I understand, during the Thanksgiving break, Conway Street Department will be paving around the junior high. Do you have those streets that we can pass so the public will know?
So it's, what we'll be doing is milling and overlaying. I believe it's going to be Duncan Street and Mitchell Street over there around the junior high. Duncan Street from Clifton to Mitchell, and then what? Duncan to Caldwell.
Good deal. And
Yeah, so
that's going
those
to be
will
done during Thanksgiving break. So I know folks are ready for us to get out of there, but it's going to be great when they get done. So just if everybody just hang on till Thanksgiving, we're going to get you taken care of. Thank you, Kurt. Mr. Hawkins, back to you, sir.
Next item is, looks like we're going to turn this over to Mr. Finkenbinder, and he's going to tell us about a settlement offer made in the Lynn v. City of Conway situation.
All right, so I know everyone woke up this morning hoping that I would talk about an eminent domain situation, and your day has come. So this involves the 6th Street overpass project. For point of reference, we're looking at the area of land that would be to the east of Logan Steakhouse along Amity. So that stretches Lynn's Auto Glass towards about the end of that parcel. So that's the area that we're talking about. This was a 2015 lawsuit that was filed by the city. It was, for whatever reason, when lawsuits are filed, they're assigned by the clerk's office, and they're assigned to whatever judge available. And in this particular case, it was assigned to a circuit judge that also handles criminal cases. In fact, most of his docket are criminal cases, and I'll get to why that's important in a second. Criminal cases get precedence over civil cases by law. So because that judge handles primarily a criminal docket, we've seen a lot of cases go to trial in his division that are criminal in nature, but not necessarily civil. So, and just for a little bit more background, my predecessor from 2015, when the suit was filed, he fought really hard for 5 years to get a trial date. That was his intention, and he did everything that he could, everything humanly possible to make that happen. It was not possible. Then around 2020, I know everyone needs this reminder, but we had a pandemic that the Arkansas Supreme Court halted all jury trials for an extended period. It was almost a year. That created a backlog that made it impossible to get a trial date anytime soon. We've been trying since I took over in 2021 to carry on what my predecessor was trying to do, is to get a trial date. We finally got one. It got moved because of a criminal case. We got another one for December. It's going to get moved for a criminal case. So that's kind of where we are procedurally with the case. Here's why the trial is important. In eminent domain cases, there are 2 ways to resolve it by law. One is if the parties agree a price for the property that's acquired by the city. If that happens, then the 2 parties would enter into a contract like any other for the city to purchase the property for the agreed price. If the parties cannot agree to a price, then the law requires that a circuit judge impanel 12 jurors from the county to decide what that fair price should be. So that's kind of where we were, and that's where my predecessor was for 5 years, that we were unable to agree. And so the law says, well, a circuit judge has to put 12 people into a jury box, and they decide. The part of the problem with that could not be avoided was that interest on any judgment that would be rendered was continuing to run the entire time, regardless of the criminal precedents of jury trials and regardless of the COVID pandemic. None of that stopped the interest rate. In the last case that we took to trial, the interest rate was 7.5% APR. So that's significant when you're talking about the kind of sums that we're discussing here. And in addition, over that time period when we were trying to get a trial date, the city's engineer who primarily worked on the project passed away, Mr. Ronnie Hall. So that put the city in a kind of difficult position. So in eminent domain cases, we start with the Arkansas Constitution, which enshrines the right of property owners as one of the highest rights protected by law. So that's where the courts would start. And the guiding principle in all this is fair compensation to the property owner for any property that's taken for a public project. No one disputed in this case from the very beginning that this was a public project, the 6th Street overpass. The problem was determining what was fair compensation. So first step is an appraisal. Real estate appraiser for both sides will evaluate the property. That has been done. There was a bit of a hitch with the property owner's appraisal. We'll get to that in a second. And I'm hoping that this is all coming through because I know this is recorded. In the case of Mary Catherine Lynn, who is the property owner, we start with the city's appraisal, which was to value the property that we say was taken at $248,250. That amount was deposited with the circuit clerk, and it is credited against any judgment or settlement. The Mary Catherine Lynn's appraiser, real estate appraiser, who's done work for the city in the past, she appraised the property at approximately $750,000. Now I'll explain where the kind of discrepancy comes from. In addition to that $750,000 during the discovery process, there was a water damage claim advanced by the property owner. We'll talk about that in a second, but that would add anywhere from $250,000 to $500,000 depending on what the outcome was at trial. So in eminent domain cases, the 12 people that the circuit court is required to impanel to decide what is fair compensation are drawn from the entire county, not just the city. In many cases, what we have seen is in some ways it's all over the map. Predicting what a jury will do is kind of like predicting the weather in Texas. We really don't know until that jury renders a verdict. We do, my predecessor and I did, though, have good outcomes on trials that we resolved for cases involving property used for the Baker Willis overpass, as well as the Central Landing project. Juries tend to go for the property owner's appraisal. That's just what they do. And once they go back to the jury room, they decide what the fair value is. So we do have a little bit of background on that. We're looking at best case and worst case scenario. Best case scenario is complete agreement with the city's appraiser of $248,250. Worst case judgment could be $750,000 to $1.5 million, depending on what they view as part of the water damage claim. I will talk about that in a second. Part of the $750,000 was a claim for damage to what's called the remainder. So when a government takes a parcel of property, in this case, that big 7-acre tract just east of Logan Steakhouse, took the northern part, right, for that roundabout, that overpass roundabout, and they had their appraisal had included a claim for damage to that remainder property, and it was based on proposed plats of that 7.5 acres roughly. But the plats had not actually been done. They were proposed plats. So my predecessor and I asked the judge to basically hold that claim because they don't have any plats. They didn't have any plats. And so I think we felt pretty good about the damage to the remainder claim being really resolved. Now, it could be revived and the judge could revisit his ruling. And I would have every expectation that the property owner's attorney would ask for a revisit on that, possibly with a new appraiser. But for right now, we had some success in getting that stopped. We advanced a similar motion on the claim for water damages. The judge has not ruled on that yet. So we don't know if any decision he would make on that. So here's the breakdown on the.
Before you move on, can I ask a question about the water damage?
Sure.
What was damaged?
So if anybody's been down kind of Amity Road, it's difficult to see now. It wasn't difficult to see probably 5-6 years ago. But Miss Lynn lives on a house that's situated on it would be the east side of the lake. There's a lake pond, and that parcel, and we do have photographs, and some of the photographs we're able to confirm with the assessor's office when they go out and assess our property, which is the most fun for anyone who owns a house. They take photographs, and we actually found out that you could see the water line about halfway out the garage. So there's some evidence of flood damage, and the claim there, to kind of sum it up, was the way the project was implemented, including the installation of box culverts that ran underneath a 40. That would have to be resolved by a jury, and that's kind of where, in our motion to sort of exclude that, we haven't got a ruling on it yet. But that's what that claim is about. It would be damage to the house.
I would think that would want to be separate from any land purchase that we make.
Yeah.
That would be my thought.
And that in part is what we argued. We just haven't got a decision from the judge yet. It's up to the judge whether that stays a part of this case or whether it's a part of a different case.
And the judge is?
That's the 5th Division Judge Foster. Any other questions before I go on into the really fun stuff? All right. So I've included some documents, not necessarily for any other reason than just to give you an idea. The first one is sort of a map of the project. It's very confusing, but it sort of gives an idea when I run through these numbers and explain where the difference comes from. There are essentially 4 parts of this acquisition. The first is the property that was acquired with an A outright by the city. And that's about 25,526 square feet. Notably, both appraisals agreed on the square footage and were within $1 of each other on square foot price. I'm going to explain where there's the deviation. So on the acquisition part, we had a total of 25,526 for total 172,500 per the city. The request from Mary Catherine Lynn was 255,260. Now the difference is not so much the price, although $10 would be a fair. What they've set it at over the 9 that our appraisal set it at. $10 would be fair, and it's justified by the comparable sale evaluation that was done. But in that acquisition parcel, 6,375 feet were attributed to no value by the city's appraiser, and that's a problem. So that was as far as the acquisition. That's the difference in the price. Was we were offering to pay nothing per square foot for 6,375 square feet. There's also a permanent construction easement, which often comes with these projects. Huge difference here in the values, and it comes down to the square footage determined to be usable versus non-usable. So from the property owner's perspective, it's property owner's property. It's valued at $10 a square foot. The city's appraiser valued only 373 out of 10,874 as having any value. So while the city acquired it, it was saying we're not going to pay anything per square foot. That difference comes out to 105,240. There's also a permanent drainage easement, 8,965 square feet, and the city's appraiser determined or opined that only 7,511 of that was offering nothing on the I don't know what's wrong with my microphone, but was offering nothing on the 1,454. That difference comes out to 22,350. There is a temporary construction easement. This is where they would set up the trucks and tractors and all that kind of thing, but that once the project was completed would no longer be used by the city. So this was really styled more in the form of a rental payment. Again, not any real dispute or difference between the amount of land used for that temporary construction easement. What the difference came down to was usable versus non-usable, in that the city's appraiser stated that 1,864 of the 4,356 square feet used for the TCE, temporary construction easement, was non-usable. So they're offering no value for, of the total acquisition, about a half an acre. The city was offering no value. So that's the difference really in the price when you extract the damage to the remainder claim, which we've really resolved, at least for now. Could be revived. That would be up to the judge. But what that does is it puts us at the property owner's valuation and would be reduced down to $267,875.
Where are you showing that?
That's the offer. So the total offer is 516. I think it's 125. And of course, the city's already deposited 248,250. So what would be left over would be the 267,875. And significantly, and so what that would do would be to pay the square foot price for all the property that the city acquired, and would compensate the property owner for costs, which we're required to do by law anyway, and for any loss of access to the northern part of that parcel. But it would also have to include a waiver of any and all claims, including any flood damage claims, water damage claims. All that would have to be waived specifically in any kind of settlement, would be my advice. But significantly, this comes down to $10 a square foot for all the property that we acquired, not just the part that we determine have no value. And that's always a problem when any government takes a half an acre and says, well, this doesn't have any value, so we're just going to take it. That's a difficult proposition to maintain at trial. The other thing, that if the council decided that they wanted to do this, was a good idea, it would also waive any claim to interest. And over 9 years, that could be as much as $415,000, $420,000.
Additional?
The bottom line, what are they asking for to settle?
$265,875.
In addition to what we
deposited.
Correct. So the total cost for the acquisition would be $516,125.
I have a couple of just random questions I guess do tie together. I don't do appraisals, but I don't know how in the world you would ever put a zero value to any piece of land. And I don't know why we would accept an appraisal that has no value on a piece of land. It's just a statement. I don't know. Are we talking about paying this additional money for the actual property that was taken and used, Are we paying for some remaining property that may have a different value now that we've taken other property? You understand what I'm saying?
It would just be for the property that was taken and used in 2015.
Okay, I don't understand the terminology then, but I thought we were paying for something. I thought this has been going on a long time. I remember when Tab was mayor.
Yeah.
I thought the claim was that the property we took negatively affected the rest of the property. That's what they're trying to get damages for.
So that's the damage to the remainder claim. That's what you're talking about and that was the part that we had filed a motion to resist that because we felt like the plats weren't actually there. It is, the way that the plats, the way that Mary Catherine Lynn planned to use this property would probably be the way anyone would plan to use this property. It'd be difficult to sell a 7-acre tract. Most likely, if you're in the business of selling commercial land, you would sell it in smaller tracts like she had planned to do. It's just that didn't have the plats. That is subject to revision, but you're exactly right. And that's the part that's really, at this point at least, no longer on the table.
So if we settle for additional 265, this is all done. It all goes away.
As long as all claims are waived, including any water damage claim, I don't think that any settlement proposal should be accepted. This is nothing against Mary Catherine Lynn. Her attorney's been great through this process, but if there's a settlement, it needs to resolve all claims, any possible claim
One
that could
final
arise out of
question.
this.
I know it's impossible to tell, but roughly, in your experience, if this were to go to trial, what would the approximate length of that trial be? Days, weeks?
The trial itself, 2-3 days. It's
9 years. They couldn't find 2 or 3 days. That's all I'm going to say.
Well, I will repeat this because I was there. I came back to the city in 2017, and I know for the 2 years before I came back that my predecessor really fought to get a trial date, and I know for sure he fought for 3 years after that to get a trial date. He couldn't get one, and part of the reason is the precedence that criminal cases get to civil cases. The judge doesn't have any discretion. Any judge. If there is a criminal case set for trial and a civil case set for trial, the criminal case goes first. Part of that has to do with the speedy trial rule, which is a constitutional right. Any criminal defendant has to have his trial or her trial resolved within 1 year of arrest. And so the judge has to, he doesn't have any discretion to say, well, I'm going to bump this murder trial because we're going to have this property dispute. He doesn't have that ability. He's got to set the criminal case for trial, which means that the civil case gets bumped. Now, the other thing that can cause a delay in civil cases over criminal cases, and I could go on for hours like this, by the way. I really like talking about this stuff. But the other difference is that in a criminal case, when the judge sets a trial date, he's not really asking the defendant, is this a good day for you? Right? He just sets a trial date, and the defendant either shows up or is arrested. The civil cases are different. This is all over the country in that the parties have to agree not only that this date works for them, but also it works for all their witnesses. And so that adds another layer of difficulty, and this is why civil cases tend to not move very fast through any court system. They probably move faster here, actually, than in a lot of other places. And this was an unusual one for those reasons. And then I think Chuck got real close to a trial date, and then COVID hit, and then nobody was having trials. That impacted the next 2 to 3 years because all those criminal cases that got put on hold, unfortunately, the rest of the criminals didn't stop and wait to commit new crimes. It would have been nice, criminals, if you're watching, take a break every now and then, let us catch up on paperwork. But so it just kind of stacked up and stacked up and stacked up.
So what you're asking of us is kind of authorization to.
Yes, so
work
Mary Catherine Lynn, through her attorney, has made this offer to resolve the case.
Oh.
And so it needs to be presented to the council. And what the council would in most cases would do would be to vote on whether to authorize the mayor to enter into that. If it met, now I do think it needs to meet that one very important condition, that it needs to resolve finally all claims
including
of whatever
interest and-
nature that could even possibly arise. And you know how lawyers are, we have language for this, but that would be something that has to be a part of the settlement, in my view.
I understand 9 years is a long time, but my first familiarity with this was when we got the agenda, and I read that, and now tonight is really the first time I've had for more questions and clarification. So what are our options for raising our level of ignorance a little more on this, as opposed to taking an action tonight?
Well, the council, with regard to this offer by Ms. Lynn, has the same options it has when any piece of business is added to y'all's agenda. It could be voted on, it could be tabled, it could be, that would be entirely up to the council, however the council wanted to vote on that.
It seems like to me that it would be prudent, though we need to move forward to a certain degree and not necessarily make a decision, but we need to refamiliarize ourselves with the details of this and do it as quickly as possible and respond back in a very reasonable time, whatever our response is.
Yeah, and Ms. Lynn, to be clear, has put no time limit on this offer of settlement. And while I think it's, full disclosure, trial lawyer and is what I do. But I realize that when I take a case to trial, I'm gambling with other people's money. And that's not a decision that I need to make. It's a decision that the people who are voted on to watch over the people's money should be making. So I don't mind trying this thing at all. But I realize that y'all want to be good stewards of the people's money. And so anything like this would have to come to the council for approval. But that doesn't mean that you have to vote on it. No one's even made a motion yet. But it doesn't mean that it has to be approved or denied tonight. That would be up to the council. And Ms. Lynn has not put a time limit on this offer of settlement.
Okay, I got a question.
Pull your mic down.
Is this going to be a firm offer from now on? Because we were talking about the interest rate steady rising. So if we wait 2 or 3 months, is the price going to go up because the interest on this loan is going to go up? Or is this just this price for now until we make a decision? Because it's already, the meter's already been running on it. I'm not talking about 2 or 3 months. I'm just talking about a reasonable amount of time. Well, I understand it. I'm just trying to find out, is there a date that we need to have it signed by, decided on to give them our opinion on this? Are we going, and the price stays at one fixed price? If we keep, not saying we're going to, if we keep putting it off, will the price rise?
It's always possible. I couldn't say to you, no, it's absolutely not going to go up. But I also don't think that resetting it for the next agenda is going to.
Well, I'm just talking about, is there?
Yeah, now if it was another 3-4 months before there was a decision, I think, because we still, we have a December trial date that we now got bumped from. So we would be trying to get another trial date. And I'm going to continue to do that unless the council decides otherwise. If the city settles this thing, then trial date's no longer needed.
All I'm thinking about is I would feel more comfortable if I went out there to look at the site, to get more familiar with the details. This is a lot of money to be spending just from reading and discussion. I'd like to, like one of my favorite terms is raise my level of ignorance. Go out there and know about it a little bit. I'm not talking about months, maybe a few weeks. Our next agenda, if we put it to that next agenda, and is that being unreasonable? No, but can I say something else? Most of us, and not saying anything negative about y'all, but most of us know what's going on. And if we putting off stuff that we trying to get a trial set and we miss that one, we're going to be further behind. And I'm just saying, I've seen it. And I'm just saying,
we don't need to drag our feet one way or the other, because we don't even know if she's gonna accept this offer to finalize everything or not. But we need to try to do it as fast as possible. And I'm not trying to say anything negative, but I know how this works in court. I'm just saying, so if you want to put it off to the next meeting, I'm fine with it. I'm not saying we got to sign it tonight anyway, but we don't need to beat the bush a long time, and we need to go ahead and decide one way or another, you know.
Is the situation with resolving all other claims, has that been discussed at all, Charles?
Only in the sense that any response from me would be that would have to be included. I would never advocate resolving a case that seems like it resolves all the claims, but if the language isn't in there, it's kind of like signing a contract that can be vague on some terms. And I don't think that, I think Mary Catherine Lynn's word is her bond. I don't know her personally, but I haven't heard a bad thing about her.
Yeah, she's solid.
But property can be
If
sold.
she's waited 9 years,
Yeah.
that ought to tell you everything you need to know about the character of that person.
When we took her deposition, I've never met a more gracious woman in my life than we did at her deposition. But property can be sold. And so 10 years from now, the city might not be dealing with Mary Catherine Lynn. It may be dealing with the new property owner, and they may examine any settlement or contract and say, well, this claim's still kind of there. I might be able to make something out of it. That's why I think the door needs to be shut. If this is resolved, this needs to be resolved once and for all.
Well, can I make a proposal that you are mentioning that to her, and we discuss this at the next meeting, what your finding is and what our decision will be? Can we, is that?
Is that a motion?
Yeah, that's a
A
motion.
motion to
That sound-
table until the next meeting?
Till the next meeting. That sound agreeable with
With
her?
the thought
Of him.
Of
of
him
taking-
talking, giving her, let us know about this is gonna be the final, this is gonna wipe everything off the table if we make this settlement.
Okay with that?
Oh, I'm just a lawyer.
I understand, but you're okay with taking that to them?
Absolutely.
I'll second that.
And we have a motion and a second to table this until the next council meeting and ask Mr. Finkenbinder to meet with Ms. Lynn's attorneys to make sure that if we pay the amount that the attorneys and the Lynn family has asked, that all other, give me the word.
Any other claim
Any other claim?
that could possibly arise from this situation, transaction, whatever you want to call it. Lawyers, this will be about 8 paragraphs. But it needs to be final. And I also want to make clear, just in case, I didn't want to insinuate this, I hope I didn't, but none of this delay is due to Mary Catherine Lynn.
No.
And the thing of it, I think we're trying to be sensitive to it, but because it's been 9 years, we just want to make sure that we have enough time to absorb all the facts and make prudent decisions. And 2 weeks on top of 9 years doesn't seem like too much to ask.
Well, I think we've got a motion and a second.
We have a motion and a second. Any further discussion? Mr. Garrett.
All in favor, say aye.
Aye.
All opposed.
Passes 7-0, just table till the next meeting. Thank you, Mr. Finkenbeiner. That's more words than I've heard you say in a long time. Thank you, Mr. Hawkins.
Sir,
Next, we have the Public Safety Committee. We have consideration to approve the disposal of a vehicle for the Conway Police Department. Chief Harris.
Good evening.
Hey.
So on the first day, we're requesting a removal of a 2008 Nissan Xterra from our inventory and to be sold at auction.
Does it run?
It does, barely.
Until you said that.
Council, back to you, unless you have any questions for Chief Harris.
I make a motion that we authorize the request for disposal of this Nissan Xterra.
Second.
I have a motion and a second to approve this consideration. Any further discussion? Mr. Garrett.
All in favor, say aye.
Aye.
All opposed.
Passes 7-0. Chief Harris, again, an ordinance to approve the appropriation of reimbursement funds for the Conway Police Department.
Yes, we're just requesting reallocation of few reimbursements, mainly, most of them are for extra duty services to be placed back in their respective accounts.
Make a
Council
mo-
I'm sorry, Mr. Hawkins.
Make a motion for adoption of the ordinance.
Second?
I have a motion and a second to adopt this ordinance to approve appropriation of reimbursement funds for the Conway Police Department. Any further discussion? Mr. Garrett.
Ordinance 02478. Mr. Hawkins?
Yes.
Ms. Mel?
Aye.
Mr. Hawks? Mr. Cummins?
Yes.
Mr. Jones?
Yes.
Ms. Isby?
Yes.
Mr. Grimes?
Aye.
That passes 7-0. Chief Harris, this just your night. Ordinance to approve the appropriation of funds for the Connect and Protect grant for the Conway Police Department.
Yes, this is a previously approved grant that the council approved, and we're just requesting to use a portion of these funds to basically pay the bills.
Good thing to do. Make a motion for adoption of the ordinance.
Second?
I have a motion and a second to adopt this ordinance, appropriation of funds for the Connect and Protect grant for the Conway Police Department. Any further discussion? Mr. Garrett.
This will be ordinance 02479. Mr. Cummins?
Yes.
Mr. Grimes?
Aye.
Mr. Hawkins?
Yes.
Ms. Isby?
Yes.
Mr. Jones?
Yes.
Ms. Mel?
Aye.
Mr. Hawks?
Yes.
That passes 7-0. Chief Harris, let's see, we have an ordinance appropriating funds for replenishment of overtime for the shop secure for the Conway Police Department.
Yes, so we're requesting 60,000 in additional overtime funds. So this year, we were right on track for the end of the year. We just had some additional things come up this year, and just for transparency's sake, Toadsuck weekend cost us 30,000 in overtime just for that weekend. Obviously, we had the eclipse, and then we did election security for this election cycle. And so that, and with the additional of, we're required to provide security for district court now. So that adds up. So this would just get us through the remainder of the year for the overtime funds. And then it's that time of year for shop secure. So that's a big hit with the citizens
It is.
and even out of towners that have that additional safety when they're shopping.
It is. That's a great program.
I will say, though, it is not a big hit with the thieves.
No.
They really don't like this program.
Council, any questions for the chief?
Make a motion for the adoption of the ordinance 02480 along with the emergency clause.
Second?
I have a motion and a second to adopt this ordinance with the emergency clause appropriating funds for the Operation Shop Secure. Any further discussion? Mr. Garrett.
Ms. Mel?
Aye.
Ms. Isby?
Yes.
Mr. Jones?
Yes.
Mr. Grimes?
Aye.
Mr. Hawks?
Yes.
Mr. Hawkins?
Yes.
Mr. Cummins?
Yes.
And the mercy clause, Ms. Mel?
Aye.
Ms. Isby?
Yes.
Mr. Jones?
Yes.
Mr. Grimes?
Aye.
Mr. Hawks? Mr. Hawkins?
Yes.
Mr. Cummins?
Yes.
Those both pass 7-0. Chief, if you would too, I know you've given it to me. Send me another copy of your overtime for this year. I would like for the council to know just how involved you guys are in the community and where a lot of your money is spent. Specifically your overtime.
Okay.
Thank you, Chief. Oh, one more. An ordinance to approve personnel changes for the Conway Police Department. Chief?
So the first, we'll do the terminal agency coordinator position. So when we, obviously, and y'all are aware, in January, when the communications center separates from the county and it's its own entity, by law, we have to create this position. And what this position does basically is anytime that we get out with a stolen vehicle, a wanted person, or anything, we would send a hit confirmation up to dispatch, and they would either enter that article, stolen article or wanted person, into ACIC, and or if we arrest somebody or recover stolen property, they would take it out. Well, by law now, since the dispatch center is going to be its own entity now, the county and ourselves have to have our own person that does this. So, let me go to the second. So the next two is since the beginning of the summer, dealing with talking and negotiating with the school district and the mayor's approval to add 2 more school resource officers to the district. which I think is a great thing, and they do too. They're very appreciative. However, with that being said, I'm asking for permission to hire those two the last 2 weeks of December instead of waiting till the beginning of the year. And the reason for it is there is a police academy, January 6th, that I would not be able to get them into. I would have to wait until April. So that pushes everything back roughly 4 months.
And I know the council knows this, but for the folks watching at home and people who know us, would you explain how we partner with the school district on that as far as cost?
So, yeah, actually, which was negotiations with the school. The school district pays for half salaries, half benefits. And then when I was talking with them this year and through conversations and I guess lack of better terms of negotiations, they're going to add an additional $25,000 per year for essentials. Because, when we were talking, they pay the salaries and they pay the half benefits, but every 5 years we're adding new bulletproof vests, or we're adding cameras, or we're adding all this stuff. So they're going to add an additional $25,000 a year on top of that to help with the cost and expenses of buying the essentials that these officers need.
I appreciate you and the school district working on it. I know you had to work with Eric King, which is hard, but
Yeah.
I'll
Counsel?
make a motion for the adoption of the ordinance 02481 along with the emergency clause.
Second?
I have a motion and a second that we adopt this ordinance to approve personnel changes for the Conway Police Department. Any further conversation? Mr. Garrett.
Mr. Hawkins?
Yes.
Mr. Grimes?
Aye.
Mr. Cummins?
Yes.
Ms. Isby?
Yes.
Mr. Jones?
Yes.
Mr. Hawks?
Yes.
Ms. Mel?
Aye.
The emergency clause, Mr. Hawkins?
Yes.
Mr. Grimes?
Aye.
Mr. Cummins?
Yes.
Ms. Isby?
Yes.
Mr. Jones?
Yes.
Mr. Hawks?
Yes.
Ms. Mel?
Hey, and so the top of that says 4 positions on the top of that, but it's actually just 3.
Okay.
So and I yield my time back to Charles.
All right. Thank you, Chief. The last bit of business tonight, council is an ordinance appropriating funds for employee bonuses. Our employees are by far our greatest asset in the city.
Mhm.
They're the ones that get out there and do the work. Anywhere from police and fire to our parks, our streets department, planning, permitting. They all do a tremendous job. Last year, we were able to give our employees $1,000 Christmas bonus. I'd like to match that again this year, $500 for part-time employees. And if you approve, then it will actually, we were going to, historically, we give it away on our Christmas appreciation banquet, but that's on the 20th, which is just 5 days for Christmas. If council approves this, we will put it in their accounts on December 13th during that pay period. So anyway, back to you, council.
So moved.
Second?
Have a motion and a second to approve the employee bonuses for Christmas this year. Any further discussion? Mr. Garrett, with the emergency clause.
This will be ordinance 02482. Mr. Cummins?
Yes.
Mr. Hawkins?
Yes.
Ms. Isby?
Yes.
Ms. Mel?
Aye.
Mr. Grimes?
Aye.
Mr. Hawks?
Yes.
Mr. Jones?
Yes.
In the emergency clause, Mr. Cummins?
Yes.
Mr. Hawkins?
Yes.
Ms. Isby?
Yes.
Ms. Mel?
Aye.
Mr. Grimes?
Aye.
Mr. Hawks? Mr. Jones?
Yes.
Those both pass 7-0. Council will have one more meeting in November, and then I think is our last meeting in December following Christmas Eve this year, Felicia. So unless if all y'all want to come Christmas Eve, we can, but
You have a gift card?
no, lump of coal, man. That's all you're getting.
Is that my Christmas present?
Yes, Woody. That's so, and it'll be the last meeting we have to deal with not only you but Mr. Garrett.
Okay.
But anyway, so we will. I think we will have the budget ready at that time too for our meeting in December. Is that correct, Felicia? Good deal. All right. With that, council, I'll take a motion to adjourn.
So moved.
We are
Second.
adjourned. Thank you, everyone.
Charles, when are we going on a field trip?
A literal field trip?
No, I want to go see that property.
Just give me a call.
Okay.
By the way, you did an excellent job
I got
explaining
stuff
all
going
that.
on.
You
You
did.
did.
You
I
did.
got stuff going on. I don't need to miss.
Oh,
Yeah.
okay.
I'll call you.
Yeah, just give me a call.
Okay.
No, no, you need me.
I could. Before I spend that much money.
Mr. Grimes?